And in the ad that you saw that brought you here today, it says, discover the dangers of joint tenancy. So let me address that. First of all, folks, most couples own assets together jointly, right? And when one dies, who owns it? The other. And there is no probate when the first spouse dies. But eventually, the second spouse dies, and then there's probate. What would happen if the two of you were to die together? Instant probate. There's no one left on the title. So just so we understand the gist of this, joint tenancy does not solve your probate problem. It just postpones it until the second spouse dies. Some people think they've come up with a shortcut, and here's what they say. Well, now that my spouse is gone and I own the house by myself, I don't want it to go to probate. I've got an idea. I'm going to put my son or daughter on title with me. That way, when I die, they take over and it skips probate. Well, it does skip probate, but it opens up so many other problems. In many cases, it's worse than probate. I'm going to give you three good reasons why you never want to own assets with your children as a way to pass the estate to them. The first reason happens to be liability. Did you know that when you put a son or daughter on title of your home or bank account, they're not just joint tenants, they are now co-owners. As a co-owner of your home, if they were to get into a car accident, their dog bites somebody, someone slips on their property, there's a lawsuit, there's a judgment, what could they attach? They could attach anything they own, and they own half of mom or dad's estate. Let's say you discover your daughter, who you put on title a few years ago, her husband, your son-in-law, is cheating on her. She throws the bum out, they divorce, but in the divorce settlement, half of what she owns goes to the ex. That's 25% of your equity that just left with your ex-son-in-law. Ouch. So when you commingle assets with your children, folks, their problems become your problems because they affect your estate. That's just reason number one. I've got two more. Reason number two, it's a bad idea to own assets jointly with your children, has to do with distribution. Let's say I made a deal with my daughter. Look, mom's gone. I don't want the house to go to probate. We'll own it together. Now, when I die, I want you to sell the house and share it with your brothers and sister. And she says, okay, Dad, I'll do it. My question is, does she have to? No, she got a house and the three of you got disappointed. And I will tell you right now, brothers cheat sisters and sisters cheat brothers. It just happens. There's no control. You lost control. She got a house and the three of you got disappointed. That's the second reason. Here's the third reason. Let's say I don't have issues with distribution. I only have one heir. Okay, so you have a daughter named Barbara and you and Barbara own the house together and you die. Now Barbara owns the house. But watch this. When she goes to sell the house, she has to pay capital gains tax all the way back to your original purchase price. So let's say you bought your house 20 years ago and paid this, and now 20 years later it's worth this. That's called a capital gain. Do you know what 20% of, let's say, $200,000 is? That's $40,000 to the IRS in capital gains tax. But folks, the good news is none of that happens when you pass your estate through a living trust. When you pass your estate through a living trust, there is zero capital gains. Everything in your trust when you die will go to your heirs at the current value. It's called a stepped up tax basis. The IRS does not care what you paid for it. What is the value when you die? That's the value that it gets transferred to the heirs. So there is zero capital gains tax due. None. That's not only on your primary residence, but it could be a second property, a rental property, or a vacation home. Or it could even be stock that you bought at $10 a share that's now trading at $100 a share. Everything in the trust gets a stepped up tax basis to the current value at your passing. So there's no capital gains. There's no distribution problems when it comes from a trust, because if my trust says it's 25% for my 4 children and I die, do you know what it says? 25%. It's not negotiable. It's not contestable like a will. The trust says what I mean, and that's the way it goes. Look at the words here. Revocable living trust means while we're living, we can do what? Change it. We can revoke our previous instruction. But when you are no longer living, the trust becomes irrevocable. And you know what irrevocable means? Cannot be changed. It is now binding set of rules. So I often tell people, if you don't like what your parents wrote in the trust, you do have the right to be disappointed, but you can't change the document. It's now binding. So much better than the will that can be argued about, that could be changed by the court. The trust, when you die, is a binding set of rules. And the last thing is liability. Just because I have a trust today doesn't mean my daughter can't divorce her husband. It doesn't mean my son couldn't drive too fast and lose control of the car and, God forbid, injure somebody. But if those events take place today, those events will affect their estate, not my estate, because we did not commingle the assets together.